Hi, Mel. Thanks for starting the meeting. Hi, Fred.
Are we starting? Am I in the right place?
You're in the right place. The meeting starts at 8:30, so that's just the business session. The cases don't start till 8:45.
Okay, fine. That's what I thought, but I just wanted to make sure I get it because I'm at camp, and so
Oh, well, that's a lot more fun than what we're doing. So,
I can see that. But I have
yeah,
on my sweatpants and my suit coat, so it's a
yeah.
good.
See, that's the beauty of the remote meeting. Who knows what anybody's got on?
Anyway, okay.
Just,
I'll
just,
just wait.
yeah. For now, I'm going to keep you muted. But
Yeah, fine. No, that's fine.
all right.
You can
Thanks, Fred.
even. Right. Bye.
Bye. Hi, Ms. Buck.
Good morning.
Morning. I know the case you're on for probably it will take a little bit for us to get to it, but we'll just keep you muted till then.
Okay, so I can go dark until then?
Absolutely.
Thanks.
Thanks. Hi there. Um, I just want to make sure I'm going to pronounce your name right. Is it Rodrigue? You're muted right now. It is. Okay. Thank you. Hi, Commissioner O'Brien. Hey, Alex.
Okay, we're all set. Thank you.
Hi, Commissioner Ashby.
Good morning. How are you?
I'm good. How are you?
I'm well, thank you.
You picked a good meeting to be chairing for. It's getting shorter by the minute,
Oh, is it even shorter?
probably even shorter.
Well, it looks like there's plenty of work to be done still, though. That's quite a litigation report.
That it's a lot. As I'm sure Commission Counsel and Deputy Counsel, I think actually Deputy Counsel, they're not attending today, but it's been a lot. Yeah.
Yeah, if we ever wondered whether they were earning their keep, I would suggest
Right.
they don't have to back up to the pay window this week. So
And do we need a Deputy Counsel? Indeed, we do.
yeah, I think we do.
Yeah.
All right, thank you, Amy.
Yeah. Hi, can the gentleman whose email or her screen name is Black Rose, can you let me know your name and what case you're here for? You're muted. There should be a little picture of a microphone somewhere, maybe at the bottom.
Blaine, it's Blaine Fenderson.
Okay. Great, thank you. Oops. Good morning, Barbara.
So do you think that we're going to have a quorum? Is Ed going to come in?
As far as I know, I'm expecting him. I'm gonna try giving Ed a call. Here he is. Quorum saved.
Good morning, Commissioner David.
Here you are.
Good morning. Good morning. Good morning. Yes, I had a disquieting message trying to connect 5 minutes ago that said I can't connect to this meeting from Canada,
Oh,
and I was about to panic and send you emails and stuff, and then I remembered that I have this handy VPN, which had
Oh.
not been turned on. So I turned it on, and Zoom thinks I'm in New Jersey, so that's all right. I'll be in New Jersey if that's what they want.
okay.
And here I am. Sorry.
That's okay. We're just happy you're here because without you, we didn't have a quorum.
Right.
We're happy you're here anyway, but also because we
Thank you.
didn't have a quorum.
All right, Amy, we're ready to call this meeting to order.
Indeed, we are. Thank you, Commissioner.
And I hereby do call this meeting to order. And our first item of business today is to adopt the agenda and the consent agenda.
But Commissioner, apologies for the interruption. Before we
Okay.
do that, and you're
Yes.
probably going to say this, but before you make a motion, anyone makes a motion to adopt the agenda, there's a request that I need to pose to you because if granted, it would change the agenda. You all got a copy of a memo from me regarding request to withdraw in H220068 A and B, which is a case on our hearing agenda today. And it is related to housing discrimination. It's Rashi versus Queen City and Parker Dresser. And this is a case where we issued a report with a recommendation for a reasonable grounds finding. Typically, we do not recommend that the commissioners grant a request to withdraw after we've issued a report, particularly when we think that the finding would be of interest to the general public. In this case, and I do think that the finding in this case would be of interest to the general public, but since we found out that the complainant had submitted a withdrawal, I had a chance to talk with counsel for both the complainant and the respondent, who are both here and who are not, I don't believe, expecting to be able to address you, but I'm glad to see them here. I do recommend that the commission grant the complainant's permission to withdraw. In this case, the complainant and respondent did agree to sign on to a public interest agreement for public interest remedies that we think are suitable if the case had gone ahead to hearing and there had been a reasonable grounds finding. So with that, I do recommend that you grant the request to withdraw. Commissioner David?
I move with that we grant the request to withdraw in H220068. I did read your memo, Amy. I was a little concerned that it's a different business entity, but hearing you say that the public concerns have been addressed, and given the other factors in the memo, I would support that.
Is there a second? Oh, thank you. So it's been moved and seconded. And just as a reminder for commissioners, as we get going, that when we are having remote meetings, we are required by state law that I that each commissioner's vote be audible and visual. So I will go through when we have a motion to ask each of you your vote, and I need you to both show and say it. So this is a motion to allow withdrawal in H220068A and B. If you're in agreement with that, then please say yes and show a yes vote. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Thank you. So with that, I would, to get back to where you were headed, I think Commissioner Ashby, the motion about the agenda and consent agenda should be a motion to adopt the agenda as amended.
Amy,
Yes.
I also, I'm not sure where this comes in, but I also think I need to recuse myself from an item on the consent agenda. Don't know what that does to anything. PA 2A-2A97.
So Commissioner, I think probably the simplest way, since this is a procedural motion to adopt the agenda, so we don't need 3 commissioners. We need 3 commissioners for a quorum. We don't need 3 commissioners to vote on each case. So
Okay.
probably the simplest thing would be for you to just abstain from this particular motion.
Okay, thank you.
So we would be looking for a motion to adopt the agenda as amended in the consent agenda from either Commissioner David or Commissioner Ashby.
I'll move to adopt the consent agenda.
And the agenda as amended?
And as amended, yes.
Second.
Thank you both. So the motion is to adopt the agenda as amended and the consent agenda. If you're in agreement with that, you will answer yes visually and orally. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
and Commissioner O'Brien is recused, not recused, abstained. So that passes. Thank you.
May I entertain a motion to adopt the minutes of the June 2022 commission meeting?
So moved.
Is there?
Second.
Okay. So it's been moved and seconded to adopt the minutes from the June meeting. If you're in agreement, you will say yes, both visually and orally. I'm going to stop saying that soon. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
got to see your hand.
Oh, I'm sorry. Yes.
Commissioner O'Brien,
Yes.
thank you. Maybe I won't stop saying it just yet.
Director's report, Amy.
Yes. So it's been uneventful, which I'm sure by saying that I will have cursed us. But we are interviewing folks for our one vacancy, which is for an investigator position. And other than that, it's been very quiet and lovely. Next for compliance, I'm just going to move through these unless you don't want me to do that, Commissioner Ashby.
Please do.
The status of reasonable grounds cases. Since the last meeting, we've had 1 successful conciliation, which I'll present to you in a minute, 1 unsuccessful conciliation, and we have 2 cases that the conciliations are pending. The 1 successful conciliation, you have a draft agreement. You have an agreement that we are hoping you will approve. In E20-0130, Jones versus Core Intelligent. I think I said that right. The memo that you have outlines the provisions and the issues. And at this time, I would ask that you make a motion to approve that. I see you, Julie, but we got to hear you.
So moved.
Okay, thank you.
Second.
There's only 3 of you, so thank you. So the motion is to approve the conciliation agreement in Jones versus Core Intelligent. If you say yes, you're in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner, I lost you already. Commissioner O'Brien.
Yes.
Thank you. Okay, for investigation, in June, there were 43 new complaints. There were 6 administrative dismissals and predetermination settlements or withdrawals with benefits. There were 4 with benefits of about $197,000 to complainants. From litigation, I would ask that we take after executive session. And for quarterly reports, you have a memo from me about training and education that commission staff delivered or attended in the quarter ending June 30th. You also have a finance report. There is, I believe, a case inventory report somewhere that I do not have, but Melody says you have it. So our minutes will reflect what is on that report, since I cannot say it aloud at the moment. And that is all I have for the director's report. There's one other thing about adopting our meeting schedule. We can do that now or in new business. Doesn't really matter.
So before we do that or discuss that, I had the same question that you just raised, and Melody, I have no reason to not trust her, but I also can't find the inventory report.
Yeah, she had said just now that it was on the, let me find the chat. She said it was on the page 1 of a report that I have. They said you have it on the summary report. So it may be that it didn't get uploaded, or it's just not in the place where we expected it to be. But if you cannot find it, I think we just lost somebody. I don't know who. If we cannot find it, I will send it to you afterwards, just so you have the information. But we can't discuss it outside of me.
Yeah, fair enough. That'd be good to have. Yeah, I see the case activity summary for June, and it does not have.
Yes.
If that's what she's referring to, it doesn't have a inventory
Right.
report.
She says no one can hear her, which is true. Melody, we cannot hear you. She says it's on line 2 of the report, and she uploaded a new version. She's messaging me. She says you cannot hear her.
Mhm.
So let's just agree that if it is not where Mel says you can find it, then I will email you a version after the meeting. And it will be, the numbers in it will be referenced in our minutes for everyone else.
Well, we have 4 minutes. I'd entertain a motion to approve the finance reports.
Actually,
Second.
you guys, you're welcome to do that, but that's actually not something that you have to do.
Oh, I'm sorry. What is it? What, remind me, what did
The
you
one
say?
thing that was left, the quarterly reports we just give to you and you don't have to do anything with them. The one thing left was to, it's a formality, but to approve the meeting schedule for 2023.
Oh, forgive me. I'm sorry. I
Yep,
missed
no.
that.
There's a lot of paper.
Is that inventory? I'm sorry. Is that the new proposed dates the same as the one that was circulated where you asked us to weigh in? Because I didn't see any response. Okay.
Yes,
They're the same. Yes.
Perfect.
I checked them and they are, yeah.
I didn't get any feedback that anyone had any issues with them.
All right. Well, let's use the time to do that then. I'll entertain a motion to approve that.
So moved.
Second.
So it's been moved and seconded to adopt the proposed 2023 meeting schedule. All commissioners, if you're in agreement, please indicate that with a yes and a hand. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes,
Okay, great. We will post those dates, and we do have conference room here at the agency in our building reserved, because eventually we're going to be back to in-person meetings or hybrid meetings or something. So that's it for, I believe, the business session, unless anybody has any other new business they want to raise. So everyone has, 2 minutes.
Great. Thank you. Good morning. I'm Jeff Ashby, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have
What's that? What's that, Jeff?
Yeah, seriously. We have additional, well, we don't. You've been provided electronically the agenda, I hope. We would ordinarily, if we were being a person, have additional agendas in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come, well, to the figurative podium. Thank you.
And Commissioner, before you call the first case, if I could just remind folks in attendance to not use the names of any third parties, witnesses, basically anyone other than the parties to the case and their attorneys here. The Maine Human Rights Act requires that the names of uninterested third parties be kept confidential. So we've given them other names in the reports that we sent you. Thanks.
Thank you, Amy. And the first case is E20-0230, Susan forgive me if I've mispronounced this, Susan Rodrigue versus Town of Benton.
Correct.
So you have 10 minutes, Ms. Rodrigue.
When I sent in my paperwork, my rebuttal was, I wanted to clarify, I actually held 2 positions. And when I submitted my report, it was confusing because it alluded to that I had resigned from my position that I was laid off from permanently. That was not the case. I resigned from a town clerk position before any of this happened. And so that's an appointed position yearly. And I was up to be reappointed, which I was, but then I resigned. I couldn't do that anymore. I did remain in my hired position, which is the position that I was permanently terminated. I had said I wanted to keep the hired position. Just to clarify, I had just resigned from the appointed position. The hired position had benefits and the appointed position had no benefits and I hadn't got a raise for 2 to 3 years. So that was my clarification, because it looked like the way I took it when I read the final results was that I had already resigned from the position, but I technically did not resign from the position that I was permanently terminated.
Okay. And just so you know, this is the final decision, what happens today. That was a recommendation.
Okay.
So before we do the next thing, let me just check and see if any commissioners have questions for you so far. Any commissioner questions for Ms. Rodrigue at this time? Commissioner Ashby?
Yeah, Ms. Rodrigue, that did jump out at me. And so thank you for clarifying that, because I think that is an important distinction. Had that been the only sort of argument in favor of the town, it really makes a difference to know that the town clerk position is different than your full-time employment position. I get that distinction now. But what also jumps out at me is that you apparently, in the course of this investigation, have stated in the fact-finding commission that you did not believe that you'd been treated differently due to your age. And that's really important, I think. If that is true, that you don't believe you were treated differently because of your age, then at least the age discrimination claim is kind of tough for you, isn't it? Don't you agree?
I guess I mean, I wasn't as tech savvy, and I guess I'm just going with, they knew I was the oldest seniority wise and age wise. I was making the most money, had the benefits, and I thought that went against me.
So you sort of have an on its face argument, like on its face, it looks like this, and that's why you believe this age discrimination.
Correct. I mean, like I say, I wasn't as tech savvy, and I mean, I could obviously do the job, but I mean, they knew I was in my 60s, which kind of went against me. And like I say, because I'd been there for so long, my salary was higher than anybody else. So.
Thank you.
You're welcome.
Any other commissioner questions for Ms. Rodriguez at this time? Seeing none. All right, Ms. Rodriguez, we will come back to you. Oh, I'm sorry, Commissioner David.
Well, yeah, I mean, I wasn't sure. Who was rehired, Ms. Rodriguez, after the pandemic?
Well,
I had a note that the old employees were rehired. It was my own note on reading it. Am I not correct?
no, they did not rehire any old employees, to my knowledge, not to do the office work. The one that remained was the select person that had appointed herself at a selectmen's meeting to be the one to remain in the office. She had the least amount of time in the job, where I had like almost 10 years. And this selectman she was also office staff. During a selectmen's meeting, she appointed herself to be the one to remain to run the office. They only kept one person, and then the other two were permanently laid off. They did not rehire us. We were permanently laid off.
Okay, and just following up on Commissioner Asprey's question, you're asking the commission to just agree with you that it's obvious that it was based on age, without any overt saying of that, right? Or mention of that.
I guess I want to say it wasn't just age. There were a lot of factors, but I was not offered the job in the past because I was a senior person. If somebody left, I was offered the job because I had the most time and I could perform all the duties as town clerk if needed. And the person that appointed, the select person that appointed herself to be the one to remain in the office, she could not do all the duties as a clerk because it was conflict of interest being a select person and a town clerk. So she could not perform the duties. And she had less than 6 months on the job. And then she just appointed herself, and the selectmen seconded it, and that was that.
Thank you.
I was sent a letter that said I was permanently terminated.
Thank you.
It came back that I could have could have applied or was offered the job, but I was never offered my office staff job back, which I was permanently terminated. I was offered the town clerk job, which is totally different.
Thank you.
Why was that unacceptable? Well, I guess that's not in the record. You were offered the town clerk job, though.
Right, but I was offered the town clerk job, which I had already, before any of this went down, I had already resigned, and I was offered the job at a less rate of pay.
And the job you resigned from was the town clerk position,
Correct.
yes?
Correct.
Okay.
Thank you, Ms. Rodriguez. Any other
Welcome.
commission, oh, hold on. Any other commissioner questions for Ms. Rodriguez at this time? Did you want to add something, Ms. Rodriguez?
I think I pretty much covered everything.
Okay, you will have time. Again, you have about 8 minutes left, but we'll get back to that after we hear from the town and their attorney. So we'll come back to you, okay?
Yes.
So then we turn to Mr. Costello.
Thank you. I hope everyone can hear me. She asked for a clarification, but that's really, in this case, it's really a distinction without a real difference, because the ultimate finding that there was no reasonable grounds for discrimination is not challenged here by her letter. And she states in that letter that there is no relevance to the job offer because it's a different job. But in just almost every case of claim of unlawful termination, asking somebody to be rehired is relevant to motivation and many other things, whether it's the same job or it's not the same job. So, I don't see that she's really challenged the findings. On the age discrimination, there were factors such as, the town's hiring pattern. They hired an older person later, and the person that stayed was actually already on the staff. Obviously, they needed somebody in the office, but due to the lack of revenue from COVID registrations, employment decisions had to be made, and that person was retained. My recollection is she had put in her application to run for selectman, not actually a selectman at the time, but I don't think that distinction is really relevant for the ultimate conclusions of the investigator, which I found well supported by the record.
Thank you.
That's it for me.
Okay. Any commissioner questions? Oh, yep, Commissioner David.
Is it, Attorney Costello, is it quote, not the same job because of the different rate of pay? Or
Well, there is a
between-
different rate of pay, but it's not the same job. There's some differing duties, but my point was just a job was offered. There was no offer. The positions that had been terminated were handled by another individual and who was already on staff. And there were obviously, reasons that person was retained.
And
Did
she
that answer
had
your
submitted a resignation, right?
Right, but that really had nothing to do with the case. I mean, that was a voluntary resignation. That was sort of just, that happened. Then she was the office staff. And then when they did the termination, there were 3 individuals. 1 remained, the other 2 were terminated.
Thank you.
Any other commissioner questions for Mr. Costello? Seeing none at this time. Mr. Costello, you'll have just over 8 minutes when we come back to you.
Okay.
Ms. Rodriguez, you have about 8 minutes left. If you want to use them, you don't have to.
Just for clarification purposes, yes, the person that remained on staff was a select person, and it was during a selectmen's meeting the selectmen went into executive session, and then they came out, and then Ms. Sloan, the select person, appointed
use the
herself.
names. Can't use names. I know you're trying not to, but no names.
The select person appointed herself to be the one to remain, and it passed. And she, like I say, she was the one that had the least time and could not perform the duties of town clerk because, like I said, it's conflict of interest. So she was like the least experienced, had the least time, and could not perform the duties as the other two, myself and the other employee, we both could. And as far as offering me the job of town clerk, that it's a job that has, well, they offered it to me at a lower rate of pay, number one, and number two, there are no benefits in that job. And the hours are very minimal. It's capped to what you can make in a year. And I guess that's all I have to offer.
Thank you. Any other questions from commissioners from Ms. Rodriguez? Seeing none. Thank you, Ms. Rodriguez. Back to Mr. Costello. Mr. Costello, you also have just over 8 minutes. If you want to use them, you don't have to. Oh, hold on, you're still muted. Hold on. Go
I
ahead.
believe the investigative report speaks for itself. The mere fact that somebody else was selected, whether she believes they were qualified or not as qualified, those are business decisions that everyone might not agree with all of those opinions about, qualifications, et cetera. And that's a business decision, but discrimination didn't enter into it. And that's really the point. With that, I'll close. Thank you.
Thank you. Any commissioner questions for Mr. Costello? Seeing none. Thank you, Mr. Costello. And now, in her very first appearance before the Maine Human Rights Commission, Investigator Courtney Byrne.
Morning, commissioners. My name is Courtney Byrne. I was an investigator assigned to this case. One note I will make is the first paragraph of my investigator's report. Should have read that complainant worked as junior office staff or respondent. So apologies for any confusion associated with that. Other than that, I don't have anything else to add, but I'm happy to answer any questions you might have.
Thank you, Courtney. Any commissioner questions for the investigator? Not seeing any. They're stunned into silence. Oh, wait, Commissioner O'Brien, did you raise your hand? Okay.
Just a comment. Welcome. Thank you.
Oh, thank you. Unless I see a hand for questions for Courtney, I'm going to say brilliant job. Yep, brilliant job. Thank you, Courtney. So then we have heard from the parties and the investigator, and commissioners, it is to you to make a motion or motions. There are 2 proposed findings here. Commissioner David?
I'll move both of them together, that we find that there's no reasonable grounds to believe respondent discriminated on the basis of age, and no reasonable grounds to find that respondent retaliated.
Is there a second? I see you, Commissioner O'Brien.
I would second that.
Okay, thank you. So the motion is to find no reasonable grounds on both claims of unlawful age discrimination and unlawful retaliation under the Whistleblower Protection Act or Maine Human Rights Act. If you say yes, you are in agreement with no reasonable grounds findings on both. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Great, thank you. The findings on both claims are no reasonable grounds, and the commission will send the parties and attorneys a letter confirming that and outlining their procedural options. And we thank you for being here today.
Thank you for your time.
Thank you. Thank you, Ms. Rodriguez.
Next is E 20-0312, Blaine Fenderson versus Bath Ironworks. Is the complainant here?
I believe complainant has counsel at this time.
Oh, counsel, thank you.
That's correct. I'm Ryan Schmitz. I'm counsel for complainant. I don't know if complainant is on the Zoom with us. I know he is.
He is.
Okay.
Oh, wait, he was. Yep, he is. There he is.
Oh, great. Yes, there he is. Okay.
You have 10 minutes, Mr. Schmitz.
Thank you. As I said, my name is Ryan Schmitz. I'm here on behalf of complainant Blaine Fenderson, and I'd like to reserve any of my remaining time for rebuttal following responding counsel's presentation. So as stated in our objection, I think there are some fundamental errors of law and fact in the investigator's report, and I'd like to discuss a few of the particularly important aspects of the case that we believe the investigator's report either omitted or erred in analyzing. And for our purposes today, I think the questions we need to concern ourselves are, first, was age a factor in BIW's decision to terminate Mr. Fenderson's employment, as in did age, influence BIW's decision not to fire him? And second, was there evidence in the record that showed a causal link between Mr. Fenderson's protected whistleblower activity and his termination? I think the answers to those questions are yes. And to answer those questions, I think we can just take members of BIW management at their words, words that were often emailed to one another and can be found in the record. And despite that, those emails were entirely omitted from the investigator's report. And I think that's a fundamental error here. By the time of his termination, Blaine Fenderson had nearly given 4 decades of service to BIW, and 30 years of those roughly were spent in leadership positions. He was consistently earning excellent performance reviews, built important relationships with his coworkers and supervisors. But in 2017, as Mr. Fenderson was nearing the age of 60, he was suspended without pay for 3 days, purportedly for violation of an unwritten and otherwise unenforced policy by not reporting to his shift 20 minutes early. He challenged that suspension under the Fair Labor Standards Act, and which began a protracted process of staying on top of BIW, emailing back and forth, and kind of fighting and appealing his suspension, which was finally reversed by BIW in 2019 with a finding that he violated no major safety policy or workplace conduct rule. And then in January 2020, only a few months after the reversal of his suspension and a few months before his 60th birthday, he was terminated with the justification for his termination as, quote, that BIW was, quote, not a priority at this point in his career, and that BIW was, quote, better off starting with new supervisors. Finally, at the termination meeting, a supervisor, the decision maker in this case, told Mr. Fenderson that he has, quote, nothing left to offer. So I think we need to look at the termination decision maker's comments. I think they leave not much to the imagination. He made a direct reference to Mr. Fenderson's age in the discussion of both the current stage of his career and being replaced by a new supervisor. Most revealing, though, I think, was his decision, or was his sentiment, that BIW had gotten all it needed out of Mr. Fenderson after 40 years of service, and that it no longer found him useful. These statements betray a bias in BIW's personnel preference for newer line supervisors, and it should be noted that the individual immediately replacing Mr. Fenderson was 15 years his junior. And now BIW's proffer justifications for Mr. Fenderson's termination are also demonstrably false, and I don't believe that was reflected in the investigator's report. Now, first, BIW reversed its suspension after finding that Mr. Fenderson had not violated a workplace conduct policy, meaning that his disciplinary record was clear. It's hard to believe that a company as large and as structured with as firm a progressive discipline policy as BIW would completely abandon that policy, which involves several steps of disciplinary, rise before termination can occur. So that it would terminate a 40-year-old worker with a stellar performance for violation of an unwritten policy that no one else had been disciplined for violating, I think strains credulity a little bit. Second, BIW cites Mr. Fenderson's failure to report vacation days as a reason for his termination. And now there's evidence in the record. Mr. Fenderson submitted screenshots with a supervisor, as well as that can be found in BIW's answer. There's an email suggesting that Mr. Fenderson's direct supervisor was aware that he was taking paid time off before he had taken it. So there's written evidence in the record that completely contradicts that assertion. And again, we just don't find that references to that really in the investigator's report, and I think that's pretty essential. As for the Mr. Fenderson being fired for his protected whistleblower activity after appealing his suspension under the Fair Labor Standards Act, I think there are several key indicia of retaliatory animus that I think deserve being called to your attention. First, in the middle of 2018, during the pendency of Mr. Fenderson's appeal, two managers in an email exchange, one of which being the ultimate decision maker behind his termination, had emailed to one another, quote, "It's time to hire and train a replacement for Mr. Fenderson." It's worth noting that the plan here is to hire a new replacement, not to promote one of Mr. Fenderson's colleagues, suggesting that they're looking to change things up, bring in somebody younger potentially. Second, there's a close temporal proximity between these emails just referenced and Mr. Fenderson challenging his suspension, only a few months. And then again, more proximity, more close temporal proximity between the final reversal of his suspension in 2019 and his ultimate termination. Third, BIW's reversal of the suspension was predicated on the determination that Mr. Fenderson did not violate a workplace conduct rule. In the intervening period between his suspension and his termination, he received no discipline for any infraction. So again, we have to look at whether, it is believable that BIW would fire a worker of 40 years who had, again, received excellent performance reviews for a one-time vacation infraction with no other disciplinary record. I think that's, not a plausible explanation. So, that out of the blue termination in 2020, I think comes off rather suspicious given the, written record of BIW planning a termination, after his challenging of the suspension. I believe that the answer to the question of whether BIW would have logically fired a worker like that with that sort of experience for something as minor as a policy violation that evidence suggests he didn't actually violate, I think the answer to that question is no. Accordingly, we believe that there are reasonable grounds to find that Mr. Fenderson was terminated due to both his age and his protected whistleblower activity. Thank you.
Thank you. Commissioner questions for Mr. Schmitz. Commissioner Ashby?
Yes, hi, Attorney Schmitz. Schmitz. I guess I want to focus on the whistleblower, the sort of definition of whistleblower. I'm not really sure how to phrase the question. Hypothetically, if the complainant had challenged some discipline because it was contrary to either private contract, or maybe a employee handbook, you agree that wouldn't be the predicate for a whistleblower complaint if he was successful and the employer had to reverse some discipline that happened. That's not a whistleblowing case. Is that correct?
I think it requires a little bit more discussion than that. I'll say for this case, though, that the challenge was under a federal labor law.
I understand that. So that if my hypothetical is correct, then the distinction in this case is that he referenced correctly, apparently, that it's a Fair Labor Standards Act violation to discipline him in this way, and that's why he was successful.
Correct.
And I anticipate that the complainant would the respondent would push back and say, but there was no report in the sort of traditional whistleblower sense, right? It's a defense raised, but is there any evidence in this record that there was a report made to, the national, I'm making this up, I wouldn't know who reinforces the Fair Labor Standards Act, say the National Labor Relations Board or someone. There was no complaint made to any authority, correct?
Well, the complaint was made to BIW's general counsel.
Right. And the Whistleblower Act references the definition of whistleblower, or at least the language used in our analyses often includes the reporting of unsafe standards and that sort of thing. This is a bit afield of that sort of definition of whistleblower, wouldn't you think?
I mean, I think reporting a violation of a federal labor law in one of, the biggest employers and most important employers in the state is certainly whistleblower activity. And I think that's, not a stretch to say that the reporting of a violation of labor law has implications well beyond just the personal situation at hand. I think, violating labor law has a host of potential workplace safety. And
all right. And so if someone were to quibble with maybe the definition of reporting, maybe raising in a defense to a discipline versus reporting to superiors because for whatever reason, whistleblowers report. If it's reporting that we're sort of focusing on, and I may focus on that, the reporting in this case occurred way back in 2017, correct? I mean, this is a years-long sort of endeavor on the part of a successful endeavor on the part of the complainant to sort of change his disciplinary record.
Well, the initial report was certainly in 2017, but as I stated in our objection and then just in my testimony just now, that this was a protracted, hands-on back and forth between BIW's general counsel and Mr. Fenderson. This was not just I wrote a note, put it on the general counsel's desk, and then walked away and waited a year and a half or 2 years. It was Mr. Fenderson was required to stay on top of BIW to continue to provide evidence to fight for his what he felt was just and what was ultimately determined to be correct, that he was not violating a workplace rule and that he did not deserve to have 3 days suspension on his record or 3 days pay taken away from it.
Do you think there's a legal distinction between reporting, say back in 2017, and maybe being retaliated against for succeeding in his claim? Do you think there's a legal distinction between those?
Well, I think they're linked, and I think that in 2018, there's emails on the record from 2018 that say it's time to get rid of Mr. Fenderson. We have to hire new supervisors. The initial plan to terminate Mr. Fenderson for his whistleblower activity, was that began in 2018. Somewhat close, much closer certainly than 2019 to when he initially reported the workplace or the labor law violation. So I think it was an ongoing process, certainly. And I wouldn't quibble with the idea of him also being terminated for his success in his self-advocacy.
Great, thank you.
Thank you.
Any other commissioner questions for Attorney Schmitz? Commissioner questions for Mr. Schmitz? Seeing none at the moment, Mr. Schmitz, you'll have just under 3 minutes when we come back to you. And then I believe it's Mr. Silver.
Good evening, Commissioner. Steve Silver from Littler Mendelson on behalf of Bath Iron Works. I'm going to take each claim separately, so we'll start with the discrimination claim. And what you've heard is that complainant's claim is based on a multi-year long plot that he alleges to replace him with someone younger. BIW actually replaced him with someone older. Okay. Initially, Mr. Fenderson was 59 when he was terminated. Initially, they moved a different supervisor from a different shift over who was 57, but his permanent replacement was 61. So this conspiracy to get younger people in didn't really materialize. And that fact alone should end the whole analysis of the claim, because that's their only evidence of age discrimination, and it doesn't even exist. Okay, the replacement was older than Mr. Fenderson. Second, BIW at the commission's request produced a lot of data about its employees. Okay, and that shows that BIW employs 358 frontline supervisors. That was the complainant's position. Of those, 51% are over the age of 40, 34% are over the age of 50. The average age is 43. Now, Mr. Fenderson was a second shift frontline supervisor. There's 76 of those. Of that, 57% are over 40 and 36% are over 50. Again, the average age is a little over 43. So these numbers don't lie, right? The majority of all frontline supervisors are in the same protected age category as Mr. Fenderson, with a third over 50. There's no great force out of older employees, as you'll see through the record. That's what complainant keeps saying. Moreover, the decision makers were also in the same protected age category. It's not like there's some young guys running around saying, "Oh, we gotta replace them," even though they replaced them with a 61-year-old. Third, Mr. Fenderson wasn't singled out in any way. The commission asked BIW to produce data about discipline for frontline supervisors. BIW produced data for 5 years, showing that it's disciplined 11 other frontline supervisors for tardiness, besides Mr. Fenderson, that resulted in 6 terminations. All right, and lastly, on May 24th of 2021, while this claim was working its way through the commission, BIW extended an offer of reemployment to Mr. Fenderson, which he accepted. It took him a while, but he returned in September of 2021. And after only 10 days back, Mr. Fenderson resigned to focus on his own side plumbing business, which now employs several people. And that is what the managers were emailing about years ago, that his own business was taking up a lot of time during the day. And that's why he was late to work constantly. And as investigator Brinley summarized in her report, right, quote, BIW later rehired complainant with full knowledge of his age, further disproving the allegation of age discrimination. So these undisputed facts overwhelmingly support the no reasonable grounds finding, right? His replacement was older than him, and they offered him his job back. So that's not age discrimination. Now let's move to the retaliation claim. I think a timeline is really important here, right? So we know in August of 2017, after numerous warnings about tardiness, BIW suspended Mr. Fenderson for 3 days. Now, when told about this suspension, Mr. Fenderson laughed and requested that BIW increase his suspension to 10 days so he could complete a home renovation. Now, obviously, his supervisor did not agree to this, and Mr. Fenderson responded, "Well, it was worth a try." Okay, now, the following week, August 2017, Mr. Fenderson filed a claim pursuant to BIW's internal dispute resolution policy challenging his suspension. An HR rep met with him and reiterated BIW's position. Nothing else happened. There was no other challenge, no communication, but about a full year later, in July of 2018, Mr. Fenderson again contacted HR questioning his suspension. Didn't submit any new information, and there was no further action taken. Then in January of 2019, Mr. Fenderson asked again about this, clearing his record, and raised this new argument under the FSLA that had never been raised before. And when it was raised, in-house counsel looked at it and agreed with Mr. Fenderson. Said there was some ambiguity because the suspension actually should have been 5 days or more. So that's what happened. Had they suspended him 5 or more days, would have never been overturned. But they only suspended him 3, and it wasn't a infraction of major safety rules. So they agreed, paid him back, and he continued to work for about another year. I'm not sure what else BIW should have done in that situation, right? They agreed, they paid him for the time missed, and he continued to work. That was the end of it. But his tardiness issues continued, failed to call out for multiple days in a row. And this notion that he properly reported his vacation is just false. Didn't follow the proper chain of command. And there's actually text messages in the record showing supervisors asking after he didn't show up for a shift, "Are you coming in? Like, where are you?" So the proximity link is totally missing, right? There's nearly a full year between when BIW agreed with Mr. Fenderson and paid him back and the employment decision here. So we've got an age discrimination claim with with no evidence of discrimination. We've got a retaliation claim based on something that happened more than a year prior, in which the company agreed with him. And then the company offered him his job back, which Mr. Fenderson accepted and decided his own business was more important. There's no discrimination here and there's no retaliation here. Thank you.
Thank you, Mr. Silver. Any commissioner questions for Attorney Silver? Wait, did I lose Commissioner David? Where is he? Do you all see Commissioner David on here?
I do not.
Well, as we said earlier, Barbara, we had a quorum when we started. We can't continue until we get him back.
Correct. Present is what counts, and he is not.
So I'm going to ask folks to pause while we try to get him back. Maybe his VPN failed.
I figured out he was an international attendee.
Yeah. We'll hopefully be back very shortly, and then we can continue. And we appreciate your patience. Okay, Commissioner David is coming back, and we'll just find out. Hopefully he heard everything that you said, Mr. Silver, but we'll just check. Commissioner David, good to have you back. Is your sound? Commissioner David, can you let us know that you can hear us?
Yes. I
Yes,
can
there
hear
you
you.
are. Thank you. Okay.
Amy, your number when you called me was 888-785-2471 or not?
I'm sorry, what?
When you called me,
Oh,
never mind.
okay. So Commissioner, I just want to check, Mr. Silver had been talking, I think when we
Right.
lost you. And he
Yep.
spoke for about 6 minutes or so, and I'm trying to figure out what of that you heard.
About half of it.
About half of that. So Mr. Silver, I'm going to invite you, and I apologize for the inconvenience. It is the new
As do I.
the new lay of the land. It's the way of the world, our remote meetings. If you can, can I ask you to repeat the second half of what you said? I know that's hard to do. You're muted. There you
Yeah,
go.
I'm I'm not sure where to go from that. If there's questions, I'm happy to answer. Yeah, I'm not. I guess I'm not sure where where to even begin. So
Okay. Well, you will have an opportunity. You'll have just short of 4 minutes to come back and make any closing remarks. Any commissioner questions for Mr. Silver at this time? And actually, Mr. Silver, I'll add additional time on. So you'll have about 6 or 7 minutes afterwards if you want to go any deeper on any points. Commissioner questions for Mr. Silver at this time? Not seeing any right now. So we'll come back to Mr. Schmitz. Mr. Schmitz, you have about 3 minutes.
Thank you. Just to quickly, touch on a couple of points. We're talking about, who Mr. Fenderson was directly replaced as a frontline supervisor for the second shift. That, as we stated in our filings, that immediate replacement was 15 years younger than Mr. Fenderson, not older. Also like to discuss the data about frontline supervisors. First, that their average age was 43. That is almost 17 years younger than Mr. Fenderson. I think that's a significant age difference, and one that can't just be washed away by the fact that it's also over 40. Third, the data that was provided about frontline supervisors and their time and attendance issues. That was the characterization of that data, just that they were disciplined for time and attendance issues with no further elaboration on that. And that is a category so vague as to be virtually meaningless. It should be noted that it wasn't just tardiness for Mr. Fenderson. It was that he wasn't showing up 20 minutes before his scheduled shift. Is that what time and attendance issues means? It's unclear that that's the case, and no data was provided to make that explicit. And then I'd also like to quickly address the whistleblower rebuttal from respondents counsel, and that it's the idea that nothing ever happened, after Mr. Fenderson initially challenged his suspension. I mean, several things happened, as he noted. There were multiple follow-ups, and he didn't just happen upon a copy of the Fair Labor Standards Act one day as he was walking to work. Like, he did work to ensure that his suspension was properly and correctly overturned. That's not nothing. That is significant time and labor that was performed by Mr. Fenderson. I think that's extremely important to remember. And so we can't just ignore that by saying, well, it was a long process and BIW didn't handle things quickly. And, when they finally were shown the light, they reversed themselves. It's like, well, no, it was a long process, and Mr. Fenderson did quite a bit of work to show that they were wrong. And with that, I am done. Thank you.
Thank you. Any commissioner questions for Mr. Schmitz? Seeing none. Thank you, Mr. Schmitz. Mr. Silver, I'm gonna peg it at 7 minutes since you lost about 3 of them the first time.
thank you. I don't think I'll fill all of them, but first, I think, in the record, and obviously I can't say their names and their birth dates, but Mr. Fenderson's replacement, we'll call CL, is 61 years old. That's just a fact. I don't know what the dispute is over that. There were people who temporarily covered his position. One was in his 40s and one was nearly 60 at 57 for a few months before the permanent replacement was filled. So these are facts, right? He was replaced with someone older. The other facts that I think are important, and maybe I didn't cover enough, is what muster is, okay, at BIW. Right, because you're going to see a lot of reference to, 20 minutes before start time. And so actually page 10 of our position statement shows a bar chart, and we took every frontline supervisor's arrival time for the first quarter of 2020 and plotted it out. And actually only 9% were after the 20 minutes early arrival, right? So at 3:40, which again shows that everyone knew what the policy was because the policy was communicated to frontline supervisors. And the reason for that is that there's a long-standing expectation that salary exempt supervisors who are responsible for managing others, they arrive prior to their shift to muster, right? There's turnover. And so you talk to the prior shift about what needs to be done. You make sure the right equipment is there, what the plans are for second shift. And some come in an hour early, some 45, a half hour. That's worked out with supervisors. And here in the record, there's a record of multiple meetings, multiple discussions. And even Mr. Fenderson doesn't deny. He was instructed and told on multiple occasions, this is when you need to arrive. And he didn't want to do it. He did for a little bit after the suspension. And then, it went off the rails. But again, that combined with the vacation issue, where he didn't properly report that, was enough. And the timeline, and then in terms of the retaliation claim, right, the timeline was protracted because BIW issued a suspension, didn't think it did anything wrong. And when Mr. Fenderson, it took nearly 2 years, when he presented evidence that, hey, you got this wrong, they agreed and they overturned it. And then he continued working for a full year. There's just no proximity there for that retaliation claim. And they rehired him. BIW, if anyone's listened to the radio or looked at a newspaper recently, is hiring as rapidly as they can. They're not in the position of just terminating people for no reason. And in fact, they wanted Mr. Fenderson back and thought that when he accepted their offer of reemployment, that he'd still be working there. He's got his own business, and that's great for him. BIW wasn't a priority at the time. Had nothing to do with his age and had nothing to do with a prior discipline in 2017 that would then lead to a 2020 employment decision. So with that, I'm happy to answer any questions that you have.
Thank you. Questions for Mr. Silver from commissioners? Commissioner David?
Yeah, I'm sorry, I am catching up here because of that internet glitch. We're talking about the turnover policy. He's suspended for objecting to that and continually ignoring it. I mean, isn't that a fair statement in your argument that he's saying it's not an appropriate policy and I shouldn't have to follow it? Is that right?
Well, that is what he was saying, despite
Right.
know, being individually discussed with. That's when he's expected to arrive.
And why is that suspension overturned? What is the reason that it violates a federal policy?
Sure. So in fact, they should have suspended him longer. If it was 5 days or more, then it would have been valid. They only suspended him for 3. And if it's that, it's got to be a major infraction. So, when this was reported, and again, there was a lot of reference to general counsel, and many of you may know who BIW's general counsel is. That's not who was involved. It was an in-house attorney who works in the HR department.
So it turns on the 3 day, 5 day major minor distinction in the federal law. Okay.
So in fact, they should have. Yep. They should have suspended him longer.
If I can be permitted, I want to ask Attorney Schmidt his reaction to that. If that's appropriate, Amy. I'm sort of lost as to where we are in the sequence here.
Well, where we are in the sequence is we have heard from Mr. Schmidt's finished his presentation. And I, if it's okay, Commissioner David, what I would suggest is maybe you can finish with your questions for Mr. Silver, and then we can go back to Mr. Schmitz if you want him to answer that.
Yeah, I think I am finished with Mr. Silver. Thank you.
Are there any other commissioner questions for Mr. Silver at this time? Not seeing any. Thank you, Mr. Silver. Okay, Mr. Schmitz.
Yeah, thank you for the opportunity to address that. So the distinction is not so much that they shouldn't have, or they should have suspended him for longer. It's that they overturned it because when they determined what the violation was, they decided that this was the appropriate discipline. It's 3-day suspension. Mr. Fenderson came and said, you can't suspend a salaried supervisor under the Fair Labor Standards Act unless there was a determination that they violated a major safety policy or a workplace conduct rule. That is what the distinction is. It's that it was determined then that that there was no violation of a major safety policy or workplace conduct rule, and that is why he was his suspension was reversed. And I think there's, it shows in the record that there was no rule. Like the policy didn't exist. There was no written example of that policy for BIW to cite to and say, this is the policy you violated. This is why we're suspending you for X amount of days. Like that's not how this played out. He brought that up to BIW, and BIW reversed itself after over a year of stalling. Thank you.
Commissioners, I think I was just going to check one last time. Any other questions for Mr. Silver or I guess Mr. Schmitz? Seeing none. Thank you, counsel. And now we turn to the investigator, Ms. Brindley.
Good morning, everyone. Commissioners, my name is Alex Brindley. I was the investigator assigned to this case. So let me just try to review these things in the order that they came up. Let's see. So let's talk about, actually, let's talk about the Whistleblower Protection Act. So I think the main crux of the issue here is whether or not the overturn of his suspension was due to the 3 days versus due to a major event, like whether or not they believed that what he had participated in was considered major conduct. I believe, based on what I've read, it aligns more with Mr. Silver's interpretation that based on the conduct or like any conduct, they would have had to suspend him for at least 5 days. And in that case, they hadn't. So that's why they overturned that. Let me just take a look at my notes. Yep, there was the mention of the lack of discipline in complainant's record. However, he did indicate, or it was indicated in the record, that he was talked to verbally on multiple occasions about having to abide by the turnover policy. And I think that's it, unless we want to get into the weeds, but I am open to any questions as per usual.
Thank you, Alex. Any commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion or motions. The report presents one recommendation with 2 claims in it.
I'm gonna suggest to my fellow commissioners that in chairing the proceeding, I'm trying to avoid making motions, but I will.
Someone's gonna have to.
All right. I move that we adopt the findings of the investigator that there are no reasonable grounds to believe that the respondent discriminated against the claimant or complainant on the basis of age or retaliated against him for engaging in MHRA and/or workplace Protection Act by protected activity, and that the complaint should be dismissed in accordance with the act.
I'd second it.
So there's a motion and it's been seconded. Is there any discussion? I forgot to ask you in the last case if you had any discussion, which I apologize about. I forgot. So in this case, the motion is to find no reasonable grounds on both claims. Any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on both age and retaliation. If you say yes, you're in agreement. Commissioner Ashby.
Yes.
Commissioner David. Commissioner David, you appear to be frozen. Let's come back to you in a second. Commissioner O'Brien.
Yes.
Commissioner David? Are you with us? I believe Commissioner David is frozen. Nope. Let's see what happens. Just so folks know, this is a first. We've had some commission staff dropping in and out, but not our commissioners. So, Barbara, what, can we have a vote since, can Ed call in as a backup? That's what Melody suggests. I will certainly.
Ed can absolutely call in as a backup. We cannot vote without a quorum, and we don't have a quorum right now.
All right. Hang on, everybody, and apologies.
Well, we can see him again, which is a good sign.
Okay. Okay. Ed and I are discussing which number he should call, and he's going to look at that. But Ed is here now. Ed, you are here.
I am.
Okay. So we have a quorum. Wait, Commissioner Ashby. Okay, where we left off, I believe, is that there was a motion to find no reasonable grounds on both claims. It was seconded. I believe there had been no discussion, but let's start back there. Is there any discussion of the motion to find no reasonable grounds among commissioners? Seeing none, I was going to ask each commissioner to reflect their vote on the motion to find no reasonable grounds on both claims. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
So the findings are both no reasonable grounds, and the commission will send parties and counsel a letter reflecting that. Mr. Schmitz, I'm not sure, were you in this case before today?
Yes, I was left out of several.
I am very sorry. That's probably on me, and my apologies for that. You will receive a copy of the letter.
Thank you.
And many apologies to all the parties and counsel for the technology glitches today. We really appreciate your patience. Thank you very much.
Our next case is E20-0360 Susan Keene versus Key Ford of York. Is either the complainant or counsel for complainant here?
I don't see either of them, which is odd.
I would note that I believe complainant submission noted that she did not have Zoom capability and was relying strictly upon a written submission for the commission's benefit.
Oh. Thank you, Bob. So, commissioners, typically when one of the parties does not appear, the party opposing the finding, the recommended finding, typically then the commission votes to adopt the recommended findings without hearing from either party, which in this case, you can't hear from the other party because they're not here.
So I guess I'd want to think a little deeper about that. If our investigator just advised us that he's aware that the complainant wants to rely upon her written submission as her argument, it doesn't sound like she's abandoning her appeal. It sounds like she's not further prosecuting, but I still think we ought to vote on the merits. And in fact, I may have some questions for the respondent in this case, or at least maybe the investigator.
Sure. Investigator Beauchesne is here and happy to answer your questions. It was in the submission that we uploaded for you all, her statement, complainant statement, that she didn't have access to Zoom and was submitting it in writing. And just so you know, all complainants, they get this information by letter, and there are phone numbers that we have plenty of folks who call in as well. So.
I agree that seems to be a statement that she's not wishing to make an oral argument. But I think we should deal with the merits.
So commissioners, how would you like to proceed?
Well, I think that probably, even though the respondent, let me double check this. Even though no, there was no response after the complainant's response. I guess probably we ought to give the respondent their 10 minutes. And then
They're not here.
They're not here either. Oh,
No.
I didn't realize that. I'm sorry.
I didn't realize that either.
Well, I still want to vote on the merits, but I have some questions for the investigator.
Certainly.
I guess I'd ask my fellow commissioners if they think that makes sense. Commissioner O'Brien, thoughts about me? I see you suggesting yes. All right. I just have a question, Bob, about the statements made by the general manager. I think I gotta look, yeah, your footnote 4 suggests those aren't severe or pervasive for hostile work environment. But can an argument be made that they're a general manager, right? So they're in a supervisory position. And can an argument be made that they're evidence of overt discrimination? I mean, the statements are, oh, you're alive. I'm not really sure that suggests to me anyway that that's discriminatory. But asking them when she's going to retire and if she's waiting to drop dead at her desk. Seems to me to be, and of course we can't attribute to the general manager the other comment about taking too long to go up and down the stairs. That is a hostile environment issue, or it's not. But the general manager's comment, when are you going to retire? Are you going to drop dead at your desk? Really does flag for me a concern that there's at least a possibility. I don't know if it's even chance or not, but there's a possibility of discriminatory animus here. Thoughts about that?
Sure. I guess, first of all, to me, this was not a hostile environment primarily claim anyway. There is also no date attached to when these alleged comments were made. Respondent did generally deny that any such comments occurred. And again, in this case, the adverse employment action was almost exclusively the furlough decision and the fact that she was not later returned to work. But as the record reflects, during the early pandemic stages, the company made a decision to reorganize its workforce so that the position that complainant held at the dealership was in fact now being consolidated to corporate in Portsmouth, New Hampshire. Complainant did not dispute that this change occurred with all title and billing clerks within the company. So the decision to take her position and have it performed at the corporate office again, does not seem to be in any way age-based. Whether or not in this particular case, the comments could have reflected that respondent may have been leaning towards that action anyway, doesn't change the fact that her position was simply eliminated due to reorganization. With respect to the other comments, again, whether or not any of them could be considered either severe or pervasive, I guess would have gone into the analysis of the hostile environment claim had that been presented. But in this case, again, the claim appeared to be primarily, I was furloughed and I was not brought back because of my age. But again, as the record reflects, 3 individuals older than complainant were returned after they were furloughed, one of whom was 10 years older than she was. So if there was a possible element of age discrimination here, the record simply didn't reflect that claim.
Okay, that helps. And then if it's in the record, and I assume that it is, she references in her response to your investigation, the question about the not eligible for rehire annotation on her apparently notice of termination, or somewhere it's notified. Did you see evidence of that? Is that true?
Again, the respondent never provided any sort of detailed explanation as to why she was listed as not rehirable in this case, whether or not, again, it was a question of simply a diminished workforce that they intended to move forward with after the pandemic. Again, there was nothing indicated in the file that suggested that decision was disciplinary based, or in fact that it was age-based. It was simply an indication on her file that she was not rehirable. So I'm not sure whether or not the employment relationship, if it had in fact ended at that point, whether or not that would be an actionable claim anyway, even if it's not satisfactorily explained by respondent why she was categorized as such.
Okay, I mean, it's interesting. Her prayer for relief, as it were, in her response is only that she wants these 32 hours back, and that makes her a sympathetic figure. But I suppose that also undercuts her case. Thank you for your investigation. I guess I'm all set.
Well, I still have, I have those same concerns that Commissioner Espy does, Bob. It seems as though the comments are direct references to age. And you say that it's disputed whether they were ever made. Did you make a determination as a fact finder as to who you found more credible?
Again, not in this case, because again, complainant's claim was not essentially alleging a hostile work environment. She was simply referencing these comments to support her claim that her age may have been a factor in why she was not returned to work after the position was eliminated. So again,
don't we have to
go ahead?
Don't we have to know why she's marked not eligible to be rehired? Was everybody so marked that was laid off in the pandemic? I mean, it seems to be critical that, yeah.
Yeah, again, I'm not certain how many other employees were listed as rehirable or not after the consolidation took place. So again, in this case, the fact that they were bringing back older employees than she was certainly suggests that her age was not a factor in why she was returned if somebody was in fact 10 years older than she was returned to her position. So again, whether or not the comments were made, as I say, certainly isn't a point that's undisputable. And again, in this case, asking somebody in and of itself when they intended to retire would not necessarily be an offensive or age-based comment. I think that there are legitimate reasons for a company to know when somebody might plan to retire, unless it got to the point where this is becoming badgering or something else where it's indicated that they're trying to force her out of her position. So again, respondent did not agree that the comments were made, and certainly there was nothing to suggest that those comments had anything to do with why she was removed from work or why she was not returned.
Go ahead, Jeff.
So I guess I do want to explore that a little further. So your findings of fact talk about the fact that after her furlough, this temporary posting, a part-time not temporary, I'm sorry, but a part-time receptionist posting became available on July 22. And then she references in her response that she was eligible for, I mean, she could have done that job. Did your investigation indicate whether she actually applied for that job?
Her allegation, from what I recall, was simply that she was not notified beforehand that that posting was going to take place. Again, in this case, there was no indication that the employer had any sort of seniority or bumping system that would have given her the right of first refusal for that particular position. It's certainly also possible that they would not have considered her for that position because it would have been clearly a step down in prestige and responsibility from the title and billing clerk position. She held the receptionist position near the early part of her employment. So whether or not they should have or could have offered her the position versus public posting, one can debate. But again, there was nothing indicating that here that her age may have been a factor in why she wasn't contacted about applying for the position.
Any other questions for the investigator, commissioners?
And just maybe for Amy, do we know why respondent is not present?
No. Presumably, they saw the same thing in her submission that we did, which said that she wasn't going to appear and that she was relying on her written submission, but I don't know.
If I could, I do recall again an email from a respondent specifically asking whether or not they did need to appear if the decision was in their favor. So I'm not sure whether or not that might have affected their attendance or not, but I do know that they did make that specific inquiry.
And that was responded directly, not counsel?
I don't believe in this case
remember?
that any attorney was present. I'm pretty sure that they have been pro se throughout, and the individual I've been dealing with, I believe, is an HR person, but I'm not certain about.
I think that's right. Yeah.
And they emailed you, Bob, or
They emailed me.
what was the response? Did you
I can pull that up if you'd like. One moment, please.
I told them what I tell everybody who asks if they need to be present, that no one's required to be present, but they have the opportunity if they want to, and
Good.
that if the person opposing the recommended decision does not appear and make a presentation, that the respondent usually will not either, that's our typical process.
Okay. I mean, I see complainants. Complainant wasn't very clear that they wouldn't necessarily attend. It's as I don't have access to Zoom, I am submitting in writing my response to Mr. Beauchene's decision. I guess I infer that that means I'm not otherwise going to show, but
Every party has the right to be here. They're all given the opportunity to be here by a number of different methods. Lots of people, when they get a notice and they don't have a computer, call up and say, how can I participate?
That's
We
what I was
walk
thinking.
them through it.
Right, that's what I mean, it's as, I infer, it's as likely that's what this person was saying, but I don't know. You can't read her mind. All right.
I think she could have found a way if she needed to.
Any other additional questions for the investigator? Seeing none. Okay, then thank you, Bob. Commissioners, you have one proposed finding that we'd be looking for a motion about. I see both Commissioners O'Brien and David.
I defer. Ed.
So was I. I move that we find that there's no reasonable grounds.
Commissioner O'Brien, were you
I'll
seconding
second that? Yeah.
All right. So the motion is
I
to
just
find.
wanted to.
Oh, yes.
Yeah, go ahead, Amy.
I was just going to say there's a motion to find no reasonable grounds on the claim of age discrimination. Is there any discussion?
Well, we've expressed the concerns that those comments are troubling. I would like to know why she's marked as not eligible, but I am impressed by the fact that this was company-wide and not just for her, and that other people rehired were older anyway. So if she didn't find a way to pursue that more and her letter doesn't continue to make a discrimination-based complaint, then I would support the investigator.
Any other discussion among commissioners? So the motion is to find no reasonable grounds based on age discrimination. If you say yes, you are in agreement with that. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
So the finding is no reasonable grounds, and the commission will send parties and council a letter confirming that. And I believe this will be our last case for the hearing agenda.
Yes, next on our agenda is H22-0057 Thomas Leak, is it? I'm sorry if it's not, versus Hubbard Farms Condominium Association. And this is a no reasonable grounds case. Is the complainant here or his counsel?
I believe Alfred, you're muted, Mr. Like. I believe the complainant's father, and I may have pronounced that wrong. Mr. Like, you're going to have to do something to unmute yourself. There you go.
Okay.
And did we pronounce it right? Is it like?
Like.
Like. All right, great. So you have 10 minutes, Mr. Like.
Okay, thanks for giving me the opportunity here to talk about this. I want to give a little bit background because you already have my written report here where I had responded. I have numbered my response from 1 to 7, so you know right away when I'm close to the end. I want to make sure that I'm not running over time because this issue is, of course, very emotional to me. Thomas, my son, is an adopted child born in El Salvador, 3 months premature, and he has cerebral palsy. He was born during the time of the Civil War in El Salvador. His cerebral palsy comes in 3 components: physical, mental, intellectual, and emotional. His physical disability is visible to everyone. You see him walking, you know what's going on. The problem which caused the problem here at Hubbard Farms is the intersection of his physical and mental disabilities. In particular, when it comes to tripping. Number 2, one remark about the summary report. It states that the president and secretary have stated that part of the complaint, or most of the complaint, was gasoline odor. This, what I call, I think that's proper English, a red herring. On the first day, on August 2nd, there was indeed a gasoline odor problem. I mentioned it and it was resolved on the first day. So on August 3rd, I thanked the ex-president to solve the problem, and I've never mentioned any gasoline or fire issue since. Now we have a workable solution. All Hubbard Farms owned items fit into the designated storage space of Unit 20, period. This unit is not deeded to anyone. It is reserved for Hubbard Farms since 2010, when I arrived at Hubbard Farms. There is a privately owned owner, a privately owned snowblower, which has caused a problem. And I took it upon myself to use my engineering knowledge to figure out a solution, because apparently no one else cared. So I went over there and took measurements, and you have a report on this from my email of May 2nd. And it is a simple thing to widen the door, and that snowblower post fits into the designated storage room.
Can you, Mr. Like, can you hold on a second? For some reason, the commissioners and Barbara and I were just brought into executive session. So everybody's coming back. I don't know why that happened. I didn't do it. I'm just telling everyone what happened. I'm very sorry to interrupt your presentation, Mr. Like. Yes, the commissioners and Commission Counsel Archer Hirsch, we all just disappeared from your hearing while you're talking. and were put into executive session. That should not have happened. So the commissioners missed about 2 minutes of your presentation. And I just want to apologize because this meeting has really technologically not been ideal. So Mr. Like, I would like to invite you, if you want to. I have your time as being at about 3 minutes so far. I think commissioners probably missed at least a minute of that, if not 2 minutes. And I don't know if you would prefer to start over again or what.
I continue with the last item I was talking about,
Okay.
I think there will be anyhow some questions, and I can come back to the previous items.
Absolutely. And I apologize and thank you.
Okay. So I was talking about item 3, a workable solution. All Hubbard owns items fit into the designated storage unit 20. It is not deeded to anyone, and it was used for that purpose for 2010. There is a privately owned snowblower, which is apparently has caused the problem. I took it upon myself to go into Hubbard Farms and use my engineering knowledge to find a solution. Apparently no one else cared to find a solution for that. And I determined that it is an easy thing to do to widen the door, and the snowblower would fit into the designated storage room. And I reported this on May 2nd. If there is need for new hardware, could happen. We don't have right now any need for new hardware that wouldn't fit into the unit 20. I suggested multiple times we could get a shed. And at the October meeting, I actually offered to a donation of $1,000 towards that shed if there was ever any need for it. So far, nobody has asked for it. We have previously had a strict policy that nothing could be put on the floor of the storage room. I was part of the elected executive board from 2014 to 2021, that's 6 years. So I know a little bit about that policy. It was clarified in 2019 when we bought a wheelbarrow and a lawnmower. And I made darn sure at that time that these would not be stored in that access floor because I had Thomas's disability needs in mind. Now, what has caused the trouble? And I think that's important to point this out. The president at Hubbard Farms is an uncompensated position, but according to the bylaws. But our ex-president wanted to be compensated. So somebody came up with this idea to create a phony facility management position, and that was paid. Okay, but the president and the facility management manager were the same person, and that caused a conflict of interest. And there was never any attempt, even though it was promised, made to delineate or to define the different duties of the president versus the facility management. It was never made. Even the person who proposed that solution felt bad about it because she agreed that having a facility management position for Hubbard Farms is an overkill because we're so small. Eventually, that private snowblower became a central element in justifying the facility manager position because there was nothing else to do. The snowblower is not needed because we have a professional snow plowing service, which cleans the snow everywhere, including to the post office boxes, to the propane tanks, you name it. That professional service does it and has done so since 2010, since I moved into Hubbard Farms, where my son moved. So this whole snowblower thing is my second red herring. Now I want to come right to my decision so we save time, or what I'm expecting, but hopefully you could help. We need a decision for the future. I'm asking for a decision that nothing can be stored on the access floor or hung on the walls of the Hubbard Farms storage room. There are no expenses in what I am requesting, none. Actually, the request is equivalent of saying, please just use this storage room as originally intended and designed. Actually, a clutter-free access space not only protects the disabled, but would also protect the elderly, those on certain medications such as blood thinner, or those suffering from osteoporosis for very obvious reasons. Anyone can trip, and is a confined space. We need a decision which is valid for the long term. The reason is that the executive board and owners at Hubbard's Farms switch frequently, and they come in with their own agenda. They can have different and powerful demands, as we have as witnessed over the last year and a half. And I can give you more examples. And these demands can cause conflict in situation at any time in the future, which could make life difficult for Thomas to access his storage units. As you probably can realize, I'm getting older, and I'm not going to be long around to help Thomas, my disabled child. Thomas is going to live at Hubbard's Farms for the rest of his life. He's not going to go anywhere. Orno is his hometown since day one. He feels comfortable and secure in that town. I hope you can help getting some kind of a resolution in place. Thank you very much.
Thank you, Mr. Leik. Commissioner questions for Mr. Leik? Not seeing any at this time. So Mr. Leik will come back to you. I tacked some time on, so you'll have about 4 minutes when we come back to you. Right now, we're going to turn to someone for Hubbard Farms.
Hi, my name is Kim Bach, and I'm the current treasurer with Hubbard Farms. We've decided that I'm going to speak to this issue just briefly. We've submitted pictures to you to show you what the condition of that storage area has been over time. We are relying on the investigator's report on this matter, but I just want to give you our understanding of how things unfolded. The first thing I was aware of was that we were brought a complaint that there was a snowblower kept within a building, that it was a gas piece of equipment, and that would be a fire hazard. We checked with the insurance company. The insurance company said it was fine. It was a storage building, not a residential unit, so that was okay. We didn't have any fault in keeping it there. We looked at the lawnmower at the time, which was folds up flat, stands up against the wall, securely put there all the way to the back of the hallway. And there are entrances on both ends of the hallway. And the wheelbarrow was hung in the same area. We didn't see that was at all in the way of the hallway for anybody. And yes, the snowblower was in the walkway, but it was clear to us that anybody could open their units fully, with the exception of the person who owned the snowblower. Their unit was blocked by their snowblower. We were not asked for any sort of an accommodation until we got the notice of the original action here. Since that time, the snowblower has been stored someplace else. And the wheelbarrow and the lawnmower, I believe, are now in the storage unit in Unit 20. We've done everything we could to try and make this a workable solution. I think that any kind of rulings about what the rules and how that storage area is kept should be left up to the condominium association. It seems to me that's where that power lies, but that, you can think about that. And I'm happy to answer any questions. We tried to respond each time to everything that was brought to us, but we were not aware that this was an accommodation. We were never asked for an accommodation. We didn't realize the full extent of the issues.
Thank you. Any commissioner questions for respondent? Commissioner, hold on. Commissioner David.
Yes, thank you, Ms. Bloch. I appreciate that you were not asked for an accommodation, and that's a legal issue that we'll need to struggle with. But you are saying that it's in response to this complaint that the snow blower is now stored elsewhere. Is that in the record, and is that a permanent commitment from somebody that's it's privately owned, right? Not owned by the condo association?
It's privately owned, but it was used to try and help blow out walkways for everybody. Since that time, our driveway has been changed. We used to have curbs. We no longer have curbs for the sidewalk, so it was more difficult to keep the sidewalks clear. And that's when the
we have a
snowblower
rule
was being used.
Thank you. We have a rule that we can't go beyond the record, but is it in the record that it's stored elsewhere, that from your point of view, the problem is solved?
The question of whether it's been moved permanently, I don't believe is in the record. The fact that it was moved, I believe is in the record.
Okay. Okay, so we can't get to that element of permanency. Thank you.
There any other commissioner questions for respondent? Seeing none, we'll come back to you, Ms. Bach. You'll have just over 7 minutes when we come back to you. Coming back to Mr. Like, I'm going to ask you to unmute again. I muted you. Now I'm asking you to unmute. So, Mr. Like, you have 4 minutes. If you want to respond, you don't have to. Or if there are things you wanted to add.
Well, you know, if they had responded to me, then I don't think we would be here today. I made 2 attempts to solve this. The first one was on August 3rd, and I was promised to get a response. I never got a response. And I could find no evidence in the minutes of the executive board meeting that there was any discussion of it. The second one was my preparation for the October meeting on October 21, I think it was. I actually wrote an 18-page paper of which had 5 or 6 items. One of them was about the storage problem. And so I managed to get that on the agenda under new items. And I talked about the storage issue, you know, I brought Thomas's disability into play, and I explained why this specific intersection between his physical and mental disability causes a problem when he touches something that's on the ground. His muscles simply freeze up and he falls over like a rock. That's his disability, and I explained this. And I used this example of his storage unit and the one of 15, which belongs the snowblower, are opposite. You do the math, you figure this out. So when he gets into his storage room, makes a step backwards, he falls right over that lawnmower, and he's falling. If he have a snow tire in his hand, there's big injury there. That wheelbarrow, which has been since removed, I agree, is particular danger for Thomas, because Thomas has a lot of material in his storage room, and to get, for example, take an item out at the end, he has to take things out, among others, for snow towers and a Christmas tree or something like this. So he's going to have to put temporary things on that ground. So he needs that space to temporarily put something, to get access to something at the very end. And it's easy to be visualized that he would be approaching that wheelbarrow and fall over. And in the association, I give the example, he could actually break his neck. So it is, unless you take Thomas's specific disabilities into account, you know, it's probably hard to understand what I'm talking about, but he cannot ride a bike. When he steps into a pothole, he falls over. He cannot control himself. You know, his right leg, he can't straighten it. As I say, I'm sure you have seen these people walking on the road with cerebral palsy. He is a typical case. So Thomas's physical well-being is very much in danger when he goes into the place and anything is stored on the floor. And I'm concerned about his physical safety in the long run. And take for example, we had time, the parking lot. We have a parking lot where the parking spaces are deeded. You can have them in the middle. There is a way to drive the car to the parking lot. Nobody would get the idea to put something into that spot because there's space, and you would ask you, well, drive around it. You know, you can get still to your parking lot. But apparently in the storage room, we are doing this. We are supposed to be able to walk around objects to get to your storage space. And it's not just Thomas. Think about it. Person with osteoporosis goes in there. They fall, break a rib. Next thing you know, they are in a nursing home. It makes no sense to have objects standing there. This space was not designed to have objects stored and where you have to walk to get to your designated space.
So Mr. Lake, I'm afraid that's your time.
Yeah, I've had it with this anyhow.
Okay, thank you.
Yep.
Any commissioner questions for Mr. Lake? Commissioner David?
Mr. Lake, your first request to have the situation dealt with was by going to a board meeting or writing to them. Is that correct?
The first request was on an email on August 2nd last year. And the second one was at the annual association meeting in October last year. And then I also
said, excuse me, you said why you needed the snow blower moved, that it was an impediment to your son?
Yes.
Yeah.
Yes, of course.
Yeah. Okay. Yeah. Thank you.
Any additional commissioner questions for Mr. Lake? Seeing none. Thank you, Mr. Lake. Now we're back to Ms. Buck. You have about 7.5 minutes left.
Yeah, I'm not going to take all that time. I would say that Mr. Lake and my recollection of those requests are very, very different. As you can imagine, if he prepared an 18-page report for our meeting, there were many, many items that were there. I have, for the first time, heard this description of his son's disability. Of course, we all want everything to be safe for everybody that's at the condo association. I think if you look at the pictures that we submitted to you, it is a modern storage facility. The aisleway is quite wide and it is neat. When I've seen the wheelbarrow there, it has been hung on the wall. It hasn't been in the walkway. And as I said, we've tried our best to rectify that problem. We've researched into who owns each storage unit. We're volunteers. We weren't aware exactly of who owned what storage unit. Once we found that 20 should be empty, and by the way, somebody deeded it to somebody else, maybe an error, but we don't know. When we found that it should be empty, that's where we put everything.
Any commissioner questions for respondent? Seeing none. Thank you, Ms. Buck. And now we return to the investigator, lead investigator Jane O'Reilly.
Morning, commissioners. As Amy just mentioned, my name is Jane O'Reilly. I was the investigator on this report. I think for the most part, I will address your questions. I think there are definitely some issues in this case, but the one thing I do want to address specifically was the question you asked Commissioner David about the knowledge that the condominium association had regarding the need for, why the request for the snowblower being moved was made. I'm actually going to read directly from my notes because I know this is a specific issue. So these are my notes from the conference where I wrote, as part of the presentation being given by Mr. Lake, Thomas's name did not come up in discussion of Hubbard Farms, didn't want to disclose disability in that audience. And then directly after the conference, I sent out the recording of the conference and got a submission and response from Mr. Lake. And the first line of that response says, did not identify Thomas, avoid emotional stress related to disclosure of disability. Instead, I emphasize the danger of bodily injury to, more generally. That's me summarizing what the rest of that sentence says. And the third sentence says, Thomas was identified only in the Maine Human Rights Commission complaint. So it may be that that's what happened. It may be that it happened the way that Mr. Lake is mentioning it today, but in terms of how I analyzed the claim in my report, that is the information that I had at the time of doing my analysis. So based on that is how I wrote my recommendation that the condominium association was not aware that the request was being made for a specific individual who was a resident who needed an accommodation based on a disability. And I'm happy to answer any other questions regarding actions and what's in the record.
Thank you, Jane. Commissioner, questions for the investigator? Commissioner Ashby?
Jane, I think that's critical. Thank you for that. As I read your inclusion in the report of the requirements for prima facie case, it seems to me that all of those are met. But as I understand you're saying that when Mr. Like made the request to the board about the snowblower, he didn't identify Thomas. He didn't identify an individual with a disability or connected to a disability.
Correct.
Okay. I mean, I was willing to overlook because I think two reasonably knew or reasonably should have known is probably met by knowing that the tenant is quote obviously disabled because he's told us what his physical limitations are. All right. Thank you.
Commissioner Ashby, did you have something?
I did. I'm still wrestling with that a little bit. Your footnote 6 in your report raises some questions for me. I guess I think from what I've heard that either there could have been a deeper analysis. With all due respect, your report's good, but we could have had a deeper analysis on whether the respondent reasonably should have known of the disability. But once you get there, and I think probably there's an even chance that the respondent reasonably should have known. And then I think that there's an even chance that the respondent would then, it'd be appropriate for them to assume that the request was a reasonable accommodation request. But your footnote 6 says that the complainant himself, and this is the son, not the father, made a couple of comments that it's hard, a little bit hard to move the equipment. And that still, I think, would be enough. I mean, if it's a little bit hard for this fellow and maybe not for others without a disability to move it, and it's in the way and it's an easy fix, it's a reasonable accommodation, I think we have a reasonable accommodation case. But then your note says, father was present at the IRC and stated it wasn't about moving the machinery. It's more about the fact that his muscles can seize unexpectedly, causing him to fall. And that probably is something that's not readily apparent or reasonably should have been known. So if I get to support, and I think I'm going to vote to support your conclusion, if I do, it's probably because of that distinction. I don't know if that's a question or not. Any thoughts about that?
My only response or thoughts on it, I guess, is that it's not really for me in the analysis of the prima facie case. It's not just the reasonably should or known or should have known of complainant's disability. It's also the next part of the prima facie case. Complainant requested a particular accommodation. So there's two parts to making sure that respondent was aware that the accommodation was for a disability, right? You have to make sure that they have knowledge of the disability, and then they have knowledge that the request is linked to that. So both whether or not they should have known of complainant's disability, even if they might have been aware through observation, even if, I don't have anything in this record that suggests they were specifically told. But I have no reason to disbelieve Mr. Lake's assessment that based on observing complainant, you may notice some mobility issues. The request to move the snowblower was never made as an accommodation by complainant. And that doesn't mean complainant would have had to make it himself. His father could have made it on his behalf, but he didn't do that based on what I have in the record. What he said in his email that he submitted and at the meeting was, this snowblower is a hazard generally to people who want to access their units because it's in the way. That's not a reasonable accommodation request. So it's both of those things together that that informed my analysis. Sorry, I'm searching for words this morning. Informed my analysis and reached my conclusion. I agree, and I didn't mean my footnote 6 to imply that complainant's assessment of his own description of his own difficulty with the snowblower wouldn't have meant he needed an accommodation. I wanted to highlight the fact that there were very different sort of versions of the report the detailed level of report of the difficulties complainant had with regard to his disability and mobility mostly came from the father. And I was going to rely more on his own reports in terms of my overall analysis. But I didn't reach that level of detailed analysis on whether or not respondent met its obligation to provide this accommodation, because I couldn't find that it had ever, again, based on what I had on the record, my view of reading what, Mr. Like provided to me and what the condo association provided to me, I couldn't find that they were ever aware they were being asked to make an accommodation based on an individual with a disability.
I see that. That's really helpful. I think I would suggest that if the father had if Mr. Like had the father had been a little quiet about, we all agree, you don't have to use the words reasonable accommodation, and you could simply point out it's difficult for my son. The case would have been made, I think, but I think I hear you saying, or at least I would be inclined to find that it's the sort of extraordinary efforts that Mr. Like has, probably out of respect for his son. I get what his motivation is, but it's almost as if he made extraordinary efforts to avoid having people think that it was because of his disability that he made this request, right? I mean, the general observations that this is dangerous for everybody, the complaints that anyone could trip and fall on this. And in fact, I think it's stated in his own submission that he avoided disclosing the disability out of respect for his son. And I think that maybe that's probably, it's commendable, but it probably is problematic. I don't think you need to actually say, I ask for a reasonable accommodation, but I think if you say I'm asking to protect the general public, you're expressly not asking for an accommodation. Is that what you're saying, Jane?
Yes, I mean, I won't speak to Mr. Lake's motivations. I mean, I'm not in Mr. Lake's head. I think, again,
right.
How he chose to make his presentation or how he chose to describe it, that's, I have to rely on what was reported to me and what was stated to me as part of the investigation. And you're right, there's no magic words. My son has difficulty because of the snowblower because he has mobility issues. We get reasonable accommodations in many forms. There's no legal requirement that you use magic words, but you do have to indicate that it's for a specific person, related to a disability. So I didn't have that in the record.
Thank you. That's helpful.
Commissioner Davis?
And I thank you, Amy. I'm fully agreeing, Jeff, that I was afraid when I was first reading it that we were focusing on the technicality that he didn't ask for an accommodation, but he's told us that he didn't want to reveal that it was specifically about his son as a matter of respect or privacy, and that's fine, and that's well motivated, but to then ask the commission to find that there's discriminatory animus is something that we can't do without that connection. So you agree with that analysis, Jane? I mean, your first answer to my question that your note said that he did not want to reveal that it was Thomas, is that indication that he's not making the connection?
Correct. I know that he is stating now that that's not true. That was part of his submission of disagreement, that he did disclose, and he was very clear about that. But that's not the information that was given to me in the course of the investigation. What I have in my notes and what I have as part of the submissions is what I read to you today. So that's what I used to make my analysis.
Any additional questions from commissioners for the investigator? Seeing none. Thank you, Jane. So commissioners, you've heard from the parties and the investigator, and you have one proposed finding.
Commissioners?
I saw Julie wave a hand. Okay.
I guess, Jeff, you're being reticent because you're chairing the meeting. Thank you. Yes, I'll move that we find there's no reasonable grounds to believe that respondent discriminated on the basis of disability, and the complaint should be dismissed.
I would second that.
So it's been moved and seconded to make a finding that there's no unlawful disability discrimination. Is there any discussion among commissioners? Commissioner David?
Yeah, I just want to say that I'm pleased that we're not taking a technical approach here, that there has to be some formal request for accommodation or some formal establishment of the disability. I appreciate Mr. Lake's advocacy for his son, but and I'm glad the problem has been solved. But I think we're agreeing that we need to have some formal connection in order to saddle a respondent with that finding of discrimination.
Any additional discussion from commissioners? Commissioner O'Brien?
Yes, again, I agree with Commissioner David in what he said. I think it's very commendable, and I think it's very tough. I really appreciate the advocacy, but I hope it's understood that there's a reasoning behind this. It's because of what was said, what wasn't said, and who said it, and that whole thing. So it's a tough one emotionally, but I think it's the right decision.
Any additional discussion from commissioners? Seeing none, the motion is to find no reasonable grounds to believe that unlawful disability discrimination occurred. If you are in agreement, please indicate yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
So the finding is no reasonable grounds to believe unlawful discrimination occurred, and the commission will send parties and council a letter confirming that and describing the parties' procedural options. Thank you very much for participating. That's the end of our hearing agenda. So at this point, we will purposely go into executive session. And this larger Zoom call will, it's as if we're there in person. The room stays open for the public if they want to stay in this meeting. And the participants in executive session will disappear. So I believe I now have the power to do that. So I'm going to try it. Let's see what happens. Actually, it doesn't let me join executive session.
You didn't demand that we make a motion, Aim.
Someone should make a motion before she figures out how to send us there and we have to come back.
I agree. Ed, that sounds like a motion to me.
It's a motion. I move we go into executive session for discussion with counsel about litigation.
And the legal rights and duties of the commission.
Yeah, that stuff too. Yeah.
Yeah.
Ed, your motion incorporates, I assume, the suggestion of Barbara, and I'll second that.
It does.
And I'll call for a vote. Now, you have to raise your hand and say yes if you are in support of the motion. So there's a motion.
I saw Jane raise her hand.
I can hear you mocking me, and we're not in executive session.
We're making a motion.
I vote yes.
I vote yes.
Yeah, the thing I forgot. Yeah.
Right.
Yes.
Yep.
Okay,
Now
we're ready.
going to executive
Wait, who made the motion? Hold on. Who made the motion?
Ed, and I seconded it.
Thank you so much. And thank you for getting what I forgot.
We ran the meeting just fine without
Of course
you.
he did. And actually, I appear to not have the power to put you into executive session. Mel, you may still have that power, but I don't know that I do. Oh, no, I do. Okay. This is just not our meeting. All right. Now going to move us into executive session, attempt number 2. And wait, we need Julie. Okay, there. All right, so Ed, did you have a motion?
Move that we not litigate PA 190487 A and B. And I move that we not litigate E 200465 A and B.
Is there a second?
Second.
Okay. So it's been moved that we not litigate the two cases, PA 190487 and E 200465. Is there any discussion among commissioners? Seeing none. I'm sorry, Commissioner O'Brien, did you have something?
No.
Okay. So the motion is to not litigate those two cases. If you say yes, you are in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
So the motion passes to not litigate those cases, and I believe that's all we have. Thank you very much. So we'll see you in August for what will be Deb's last meeting. So, you know, prepare your hosannas and speeches and, you know, things. Just kidding. Barbara,
Didn't we keep Ted on for a year after he tried to leave?
We did. My information from Commissioner Whitworth is that she is retiring, really retiring.
Oh, okay.
So I really wish we could keep her for a while, but the governor's office asked me the same thing. And I said, I don't think so. Yeah.
So you cut out just a second ago when you were announcing the news regarding her. Did you say the next meeting she's doing is her last meeting?
Yes.
Okay,
So she'll be at the August meeting, and after that, not there. Unless she changes her mind, which maybe she will. Maybe if we all beg, she'll show up. I don't know. But all right, thank you so much. We'll see you in August.
Thank you.
Bye.